Wow, what a great turnout. I guess a lot of people remember the Mueller report after all. Good afternoon. Welcome to Politics and Prose. I'm Brad Graham, the co-owner of the bookstore, along with my wife, Lissa Muscatine, and we are really very excited to have with us three key members of the special counsel team that was led by Robert Mueller and that investigated Russian interference in the 2016 presidential election. The team members, all lawyers, of course, Aaron Zebley, James Quarles, and Andrew Goldstein, have written a new book, Interference, which is the inside story of their investigation. Aaron was Mueller's deputy, Jim was senior counselor, and Andrew was a lead prosecutor. You don't normally see lawyers from a special counsel investigation turn up in a bookstore to tell you what really went on. But these guys have been, for the last few years, actually teaching a course on their work at the University of Virginia Law School. So they're pretty practiced at this, although I think this may be their first time in front of, a really tough audience like a bookstore. It's been 5.5 years since the release of the Mueller report. 5.5 years, can you believe that? It's 448 pages documented that the Russian government had indeed engaged in multiple systematic attacks meant to undermine American democracy and favor Donald Trump over Hillary Clinton. Although the investigation found no evidence that the Trump campaign had actually coordinated with the Russians on election interference, it did find contacts between the two sides. And on the question of whether Trump had obstructed justice by interfering with the investigation, the report refrained from providing a conclusion, but did cite multiple instances of interference that could potentially constitute obstruction. By detailing how the Mueller investigation unfolded and elaborating on its findings, Aaron, Jim, and Andrew hope to clarify the confusion that ended up clouding some of their work. If you're in your mind, you can't quite remember, well, what did they conclude? There's a reason for that. And it resulted in large part when Bill Barr, who was then the Attorney General when the report was released, issued his own inaccurate and incomplete summary of the findings. And you're going to hear more about that in a minute from the team members. Now with only a few weeks to go before the next presidential election, this look back by Mueller's associates is especially relevant because, as the authors note, the threat of interference by Russia and others hasn't gone away. But the book's also relevant because, as Mueller himself notes in a preface, appointments of special counsels have become more commonplace. And there are lessons that can be learned from the experience of the Mueller team, lessons about the benefits and the limitations of such investigations. The kinds of challenges faced by Mueller's group are the same ones that may be faced by future counsels, like when should a president be subpoenaed? How should a special counsel interact with the attorney general? How can a special counsel investigate a president and hold him accountable for criminal conduct? And of course, that last question has become even trickier in the wake of last July's ruling by the Supreme Court, which granted the president immunity from prosecution when exercising core constitutional powers or engaging in some other official acts. If that ruling had been in place at the time of the Mueller investigation, it would have limited, if not eliminated, multiple aspects of their work, which really would have been a huge loss for our democracy, to say the least. Please join me in welcoming Aaron, Jim, and Andrew.
Hi, everybody. My name is, a little closer. My name is Aaron Zebley. We're going to take a couple minutes to add to Brad's introduction, tell you a little bit about what role we played in the office and how we ended up there. And then we'll do a little bit more table setting in terms of sort of what the context was when Bob was appointed and we kicked off the investigation. So I was Bob's deputy in the office. And at the time of his appointment, I was his partner at a law firm. And before that, I had been his chief of staff when he was director of the FBI. So we had a longstanding relationship. So when he was appointed, or actually in the run-up to his appointment, in those last few days before he was actually appointed, he said, look, if I go, I'd like you to go with me. And there was really only one answer for that with Bob, and that was that I would go with him. Just 1 minute on some history. I'm going to go back to the beginning, May 2017. So on May 9th, 2017, then President Trump fired Jim Comey. Jim Comey was the director of the FBI at the time. At that time, Trump had been in the seat as president for about 3.5 months or so. And Comey had been in his seat for about 3.5 years. He had succeeded Bob as director of the FBI in September 2013. So Trump fired Comey on May 9th. At the time of the termination, FBI was investigating Russian election interference from the 2016 election. And they were also looking at potential links and coordination between Russian election interference and the Trump campaign. And the days after that, after Comey was fired, the president seemed to link his decision to fire Comey with the existence of this investigation. And then within a week or so, Rod Rosenstein, who was the acting attorney general for the Russia investigation, he appointed Bob as special counsel. Jim.
Good afternoon. I was one of the youngest people on the Watergate staff and one of the oldest people on this staff. People said you were kind of too young for the last job and maybe you were too old for this one. But I'll tell you a little bit about how it is I ended up in Watergate to start this out. I had a friend who's actually a good enough friend that he's here today, who advised me, don't take Archie Cox's final exam. We need to write papers because we'll never get through his final exam. So we wrote 3 papers for Archie, and it was a beautiful team. He could think and I could type. And so we got through those 3 papers, and when Archie was appointed, my friend called and said, I'd like to come. And Archie said, I'd love to have you come. And they then talked to me, and my judge said I could go. So that was Watergate. Bob Mueller was a force of nature in Massachusetts, which is where my law firm was headquartered, even though I was here in Washington. He was a terrific prosecutor. When the U.S. Attorney's position was vacant, the judges unanimously appointed him as the U.S. Attorney. And he just had a phenomenal reputation. He then left there and came down to Washington and had several positions in the Justice Department. And then in 1993, when the administrations changed, I called Bob and ultimately convinced him to come to our firm. He was tremendously successful except for one thing. He decided that his calling was to put people in jail, not to get them out of jail. So he left and became a line prosecutor in the U.S. Attorney's office here. From that, he became the U.S. Attorney in San Francisco, then the FBI director. That was extended for 2 years. And in 2013, I convinced him, along with others, to come back to the firm. And we were having a great time. Aaron was with us, and we were on our way to the settlement of the Volkswagen clean diesel case when Bob got the call to come. And like Aaron, he said, would you come? And I said, well, yes, but I'll have to ask my wife. So I called my wife and went back into Bob and said, Bob, I talked to Sharon, and she didn't say no. Bob said, "Great, when can you start?" And I said, "Well, she just started to cry." But we were able to patch that up as a matter of family law, and we moved on. We moved on, and on May 17th, Aaron and I and Bob all resigned and started down this journey.
And Sharon is here today.
She is.
Family law is not a reference to divorce. They're still together.
Yeah. Believe me, I cleared that.
So I'm Andrew Goldstein. I'm now the head of the white collar practice at the law firm Cooley. And by the way, thank you all for being here. This is kind of a ridiculous turnout, and a lot of you I know have come from far away to hear us, and we're delighted by it. So I was a prosecutor in New York when Jim Comey got fired, and when these guys were working with Bob Mueller at their firm in DC. And I was the head of the public corruption unit, and we had this fast-moving case involving Paul Manafort, who had a set of Russia connections that actually weren't part of our investigation, but also had what looked to be a potentially corrupt relationship with a Chicago banker. And so we were working on that. When Jim Comey got fired, in the legal world, this was like a gigantic earthquake. Among normal people, maybe not, but it was a very big deal. And then just a couple days after that happened, and then after Bob had been appointed special counsel, I got called down by Aaron, Jim, and Bob to present on our Manafort case, so they could see if they wanted to basically take over that case. So I did. It was the first time I had met any of these guys. It was a nice, I was not auditioning for a job working with them, but it was an honor to present to them. Soon after that, after they vetted the hell out of me, they asked me to come join the team. And that's how sort of I became part of this group. So for today, what we're gonna do, there are three of us, so we thought it wasn't great to have a moderator. So instead, we're gonna self-moderate and sort of ask each other questions and tee things up for each other. We're going to try to hit some of the things that, as the book came out this week, and people have been asking us a lot of questions about the book, and we're trying to channel the things that people have been most interested in. And we're going to start with some of the really key issues that I think people have been most interested in. The first is, it's sort of what Brad said. What the hell are you guys doing writing a book? You're prosecutors. Why? Why do you think this is relevant now? And I'll give that to Aaron.
So the book was really an outgrowth of a class that we've been teaching at UVA School of Law for the past several years. We started teaching it in 2021, and the class focuses on the hardest decisions that we had, that the legal framework was for the decisions, the political ramifications decisions, human dimensions. And so we've been thinking about these issues for a while, lessons learned from the course of the investigation, mistakes we made, and Brad has already mentioned some of them in his opening. And so we developed this idea for a book, and it took us a while to convince Bob that it was the right thing to do, but we eventually prevailed on him. And so we launched the writing of the book, and we think this year it has particular relevance, and Brad touched on some of these issues as well. One, because the book is a lot about Russian election interference. It really did happen. It definitely was not a hoax. Russia interfered in the 2016 election in sweeping and systematic fashion. We say that in the report is the first sentence. We say it in the book. It really did happen. A lot of people deny that. A lot of people don't know that. So we thought it was of particular relevance this year. And it's happening again, actually. It's not just the Russians as well. There are other foreign powers who are interfering. So that was one reason we wanted to do it this year in particular. And then the second major issue we thought, or point we wanted to touch on, is the importance of being able to examine a president's conduct. And we hope we did that with integrity, and we try to show how we did that in the course of the book. And that pertains to former President Trump or any future president. So those were the two things that we thought had particular relevance this year. And as Brad previewed, as it happens, there are a couple of Supreme Court decisions that made it particularly timely. And Jim's going to comment on the special relevance of some of the recent Supreme Court decisions.
Yes. Excuse me. As we were literally looking at the page proofs of this book, It had gone through every possible review there was. On Friday, there was a decision about the breadth of the immunity statute, or the breadth of the obstruction of justice statute. And then on Monday, we had the immunity decision that came down from the Supreme Court. And I'm sure many of you are familiar with it, but the way to sort of think of it is the court held that there was 3 concentric circles. At the core of the circle is the activities that are committed to the president and to the president alone. As to those, there is absolute immunity. There is another circle that goes around that, which deals with official actions. And as to those, there is presumptive immunity. And then beyond that circle, there is no immunity for unofficial acts. Much of the discussion about the decision has focused on the question of, well, can a president be indicted? Can a president be the subject of a criminal charge? That's an important question, but there's an equally important question that lurks within that decision. And that is, can someone be investigated for those activities? I have suggested to some of my friends from Watergate an interesting thought experiment would be, what part of the things that were part of Watergate would not even be investigatable under the current understanding of immunity? And so one of the issues that we did not anticipate as we were starting to write this book, we were hoping it would help future special counsels, is, will there be future special counsels? And if so, what will be their roles? What will be the ability they have to use the powerful tools of a criminal investigation to figure out what is going on? We think, most people I think, believe that in Watergate it was helpful to learn what had happened. And we hope people believe that it was helpful to learn what happened in this instance. Whether the current regime will allow that to happen, we'll have to wait and see what the courts do along the way. So, Andrew, you, speaking of investigating things, you were one of the lead investigators and the lead prosecutors on Team 600, which was looking at the question of whether there had been obstruction. And there was this question of, should we subpoena the president or not? And perhaps you could give some people some thought of how it is we approach that. It's discussed heavily in the book, but tell us how that worked.
And this is a topic that we spend a lot of time on in our class as well. So there came a time pretty early in the investigation where we knew that we wanted to ask the president a series of questions. We had questions about connections to Russia, and in particular what he knew about connections between members of his campaign and either Russian cutouts or Russian agents or actual Russians. And we also, as we were doing the obstruction investigation that I worked on with Jim in particular, we had questions about his own conduct. Why did he fire Jim Comey? Was he trying to basically scuttle the Russian investigation? Was he acting in ways that were potentially corrupt? So we had these questions, and early in the investigation, it looked like the president might be willing to meet with us. His lawyers were pushing us to move as fast as we could, and we were trying to move as fast as we could. And his lawyers thought that if Trump came in and met with us, sat for an interview, that could make our investigation end more quickly, and we could at least, we could investigate the rest of it, but the investigation as to Trump could be over. So we actually had a date. We were going to interview him on January 27th at Camp David. We began to develop questions. We were sort of ready to go. But as the winter of 2017 came through, and our investigation on everything else progressed, and we started charging people with crimes, people started cooperating, and their cooperation became public. The president's tune began to change, and it became clear that he did not want to testify. And we'll go back to that in a minute. But ultimately, it became clear to us that we were not going to get a voluntary interview of the president, even though, and we made this clear to his lawyers, that every single president who has faced an investigation, anything like ours, has always ultimately met with prosecutors and has given an interview. But we were told and we knew that that was not going to happen with Trump. So we started to consider, should we issue a grand jury subpoena? And the book goes into great detail about the way that we analyzed the issue, the discussions that we ended up having with the president's lawyers and within the Department of Justice, and then ultimately why we decided not to issue a grand jury subpoena for his testimony. And like the 2 points I want to make about that, and then we may come back to this. But one is people think of special counsels, I think, as having more independence and authority than they actually do. Prior to us, there had been an independent counsel regime that Ken Starr, who did the Whitewater investigation, that he was operating under, that had a lot more freedom to basically do whatever the heck he wanted to do. He had the full power of the Attorney General as an independent counsel. That ultimately got thrown out. The statute that authorized that lapsed. And so we were operating as a special counsel underneath the Attorney General. And the one part of that is that we couldn't on our own just go ahead and issue a subpoena to the president and have it be, all right, there you go. We knew that this would get litigated all the way to the Supreme Court, and that we would be taking legal positions about the ability and the authority to question a president in a way that had never been tested before. We wanted to ask some questions about obstruction of justice that were sort of on the edge of what existing law was about at that point. And so we needed the support of the Attorney General to be able to issue a grand jury subpoena. And the book talks about how we had a long back and forth, and ultimately we got the support solely to issue written questions to the president, which all of us thought were useless, but we weren't authorized to issue a grand jury subpoena. And then by the time that process played out, we had already gathered a ton of information from other sources. It was late in the investigation. If we went and issued a subpoena, it was going to probably take a year or two to litigate. And so finally, in the end, Mueller decided, and when we all agreed, that it wasn't worth forcing the issue with a grand jury subpoena. So
there's a lot in there. I'm just going to add on, I'm calling an audible. This is not part of our script. Andrew described the independent counsel statute, which was live from 78 to 99, and then it lapsed, and we ended up with the special counsel regime. The independent counsel statute has its own set of problems. So I don't know that we're not advocating for that as the ideal model for how you might go about investigating the president. It's a complicated issue. That whoever investigates a president needs to be both independent and have a measure of accountability, and there are constitutional limits on how you can do that. So I'm not sure the independent counsel statute's the right answer. Anyway.
So we want to go back in time a little bit to the decision about a subpoena. The book talks about some of the discussions that we had with the president's lawyers, and the president changed lawyers midstream. So Jim, can you talk a little bit about the sequence of events that led us to that?
Sure. I had been dealing with John Dowd for essentially the entire investigation. And then it became clear that
Say who John Dowd was.
John Dowd was representing the president, had famously investigated Pete Rose, was a well-known criminal defense lawyer here. But John had resigned shortly after the original agreement to have a interview at Camp David fell apart. And the president also was represented by a fellow named Jay Sekulow, who has argued a number of Supreme Court cases. Very easy guy to deal with. And so he came over and told us that John had left. And as we're waiting for our security people to take him out so he wouldn't be seen, he says, but I've talked to some people, and they're going to come in and represent the president. He said, 2 of them you know really well. You're going to find it very easy to work with them. There's a third person, and I'm not so sure how that's going to work out. He may not actually come on. Well, he actually did come on. It was America's mayor. And Andrew, we resisted reading to you from our book. We hope that you'll read it, but we didn't want to read it to you. But Andrew has a section of it which talks about the first meeting that we had with America's mayor.
This will be short, but we tried in this book to not make it too lawyerly and to tell it as a narrative of the major things that came up in the investigation and the decisions that we made. So this is just a section of the book that chapter 12 titled America's Mayor. So Bob attended only one meeting with Rudolph Giuliani, President Trump's newest personal lawyer. The meeting took place on April 24th, 2018 in the windowless Elm conference room at Patriots Plaza, with its drop-paneled ceiling, mismatched office chairs, and audibly buzzing fluorescent lights. We came to the meeting with one goal in mind, for the president's new legal team to agree to an interview. We met with Bob in advance and confirmed that if the president's lawyers hedged on an interview or tried to throw up roadblocks, Bob would repeat that an interview was necessary for us to complete our investigation. And if that didn't work, Bob would raise the issue of a subpoena. So at 4 p.m. sharp, we walked in to Elm. Giuliani wore a black suit with pinstripes and flashed his large diamond-encrusted New York Yankees World Series ring on his left ring finger. Bob shook everyone's hand, and then we sat. Bob in the middle of one side of the long table, Giuliani directly in front of him. Right before we started, Bob looked at Giuliani and then at the others and said, "Our ability to work well together depends on having what we say in this room stay in this room." Giuliani immediately agreed. "We have great respect for the work you've been doing," he said, "and you've been doing it in secrecy and in a professional way." He then said, "We want to resolve this and come to an agreement soon on an interview. We want to get this done." Jay Sekulow, who Jim mentioned, jumped in and said, "World leaders raise the investigation with the president and even ask him if he's still going to be president. We have to get this behind him." Now, we had heard a version of this comment in nearly every meeting with the president's lawyers, how our investigation was burdening the president and affecting his ability to conduct foreign affairs. So Bob responded, "We recognize how important it is for the president to be able to do his work. And we also understand the impact on others who get drawn into the ambit of an investigation. With that in mind, we've moved as swiftly as possible and we've had no leaks." The book then goes through the actual substance of the meeting and the discussion, the back and forth we had with Giuliani, and then talks about how a few weeks later, Giuliani appeared on multiple press outlets talking about the meeting and misstating several details. So the book then says, Bob decided after that he would never again meet or speak with Giuliani, and he never did. For Bob, it was a matter of trust. Giuliani had promised that he would keep the meeting confidential, then he broke this promise, and he broadcast inaccurate information. And the upshot of that is that Jim and I, who were the ones dealing with the president's lawyers on a regular basis, we tried to only deal with his other lawyers and were able to avoid dealing with Rudy as much as humanly possible. So one other thing that Giuliani did publicly, after that whole chain of events, is he talked about potential pardons for witnesses and others involved in the investigation and people who we were investigating. And the president also talked about potential pardons. So Aaron, how did the office think about that?
So before I answer the question, I just want to go back to Jay's introduction of America's Mayor. That the first thought we had was, Pete Buttigieg? Didn't see that coming. I stole that joke from Preet Bharara, by the way, but I thought it was hilarious. Anyway, It was Rudy Giuliani. So as Andrew said, there was a lot of talk about our investigation, about it being a witch hunt, coming from the president and coming from the president's team, Rudy Giuliani in particular. But the one thing that was slightly different than just calling us a witch hunt is some of the talk that that Andrew described. There were comments about the jury and what the jury should do with Paul Manafort's case after his trial in EDVA. There were comments about people who might or might not cooperate with our office, including through this idea of possible pardons to clean up the outcome of our investigation. And so we actually did think a lot about that, and we write about it in the Mueller report, and we write about it in the book as well. And what we saw in that is that there really was a potential for an impact on people who are contemplating cooperating with us. One tool of a prosecutor. You should only charge cases if it's a righteous case, but at the same time, when you charge someone, it creates an incentive to cooperate with you and hopefully get you to more information and allows you to continue in the investigation. And so in this talk of pardons, we saw this potential to have an impact on cooperation. And in fact, in the Mueller investigation, we concluded that there was evidence that some number of witnesses who might have otherwise cooperated with us opted not to cooperate in hopes of getting a pardon. Paul Manafort comes to mind as someone who took that path. And as things played out, at the end of our investigation, well, actually a year or two after the end of our investigation, at the end of the Trump presidency, President Trump did end up pardoning some number of people, all of whom had declined ultimately to cooperate with us. And the folks who didn't get pardoned were the ones who actually had cooperated with us. So we saw in that a potential to actually affect the course of a criminal investigation. I'm now going to turn to the question that I think most people want to know the answer to, which is, why on earth did you guys not reach an ultimate judgment about whether or not the president committed a crime? And I'm going to hand that to Andrew.
I get the easy question. I will say, just on the issue of pardons, I mean, the idea that at the end of his presidency, everybody who did not cooperate gets pardoned, and all of the people who did cooperate, like Michael Cohen did ultimately cooperate with us. Rick Gates, who was Manafort's business partner, cooperated with us. None of those people got pardons, and that, like, as a former DOJ person, it's sort of antithetical to the way that the whole system's supposed to operate. You want to give people an incentive to actually help and provide information to the government. So, the hard question: why is it that we ultimately decided to effectively review and document and catalog the president's conduct, but not conclude one way or the other whether that conduct constituted a crime? And the book talks about some meetings that we had internally where this issue came up. And the short version is that, what Jim talked about as Team 600, which is named after the regulation that gave us the authority to investigate obstruction of justice. It's very geeky, but it's the regulation is called Regulation 600.4, so we named ourselves that. But as we were basically at the end of our investigation of obstruction of justice, we decided that we were going to hold everything together and start to talk about the merits. Like, is this, when you look at all the evidence here, does this constitute a crime? And as we did that, there was one major obstacle on the table that we were all very aware of. There was an opinion that was written by the Office of Legal Counsel of the Department of Justice that said that you could not charge a sitting president with a crime. And that's actually was sort of a re-up of an earlier opinion from the Watergate period that said the same thing. So since we were operating within the Department of Justice and under the regulations, we had to follow the policies and the procedures and practices of the Department of Justice. And there was legal opinions within the department that said you can't charge a sitting president with a crime. We agreed to follow that. If there were some extraordinary circumstance, for example, if we had found evidence that Trump was actually like a Manchurian candidate taking orders from Russia, maybe we would have gone back to DOJ to try to get them to revisit that opinion. But we didn't have that evidence. And so we were committed to following this OLC opinion, which said we can't charge the president. So then the question is, if you can't charge him with a crime, so what do you then do? And if you look at the OLC opinion and you look at sort of the reasons for it, they say that it is up to not a single prosecutor to make an accusation of wrongdoing against the sitting president. It's actually up to Congress. It's up to the House to bring impeachment against the president, to bring an accusation of wrongdoing, because the House is an elected body and it's part of the political process. And so the combination of the fact of the opinion itself, so we couldn't charge him with a crime, and the fact that you couldn't, according to the reasoning of the opinion in the Constitution, it's really not up to one prosecutor, Bob Mueller, to make an accusation. The combination of that sort of led us to think that the better course here would not be to go through the process and ultimately say one way or the other, does this conduct amount to criminal activity? But instead to effectively lay it out so that, like the Attorney General in the first instance, and we had been told that this was going to be, he was going to be transparent with our findings, that ultimately the American people in Congress could see the conduct for themselves and make their own judgments. There's parts of this that I think Jim will touch on as well that also went to sort of basic senses of fairness and judgment.
Yeah, I think one of the things, and believe me, there was a lot of thought and a lot of talk around the office about what to do in this situation. But one of the things that every prosecutor knows is when you recommend that a charge be brought, you're going to have to try that case. And if you're in a situation where that case can never be tried, you don't have working on you that question of, I have to try this case. Do I believe it enough? Do I believe it enough that I'm going to charge this case and ask a grand jury to return an indictment? And so one of the things that I think many of us struggled with was, what is the reason? Why would you essentially say, j'accuse? We think you committed. Why would you go down a road that would have you possibly saying you committed a crime in a situation where there's no ability to defend yourself, and you as the person making the judgment would never have to stand behind it and stand in front of 12 jurors and try and prove it? So for that reason, that was one of the reasons. The Office of the Legal Counsel was clearly the most important reasons. But that was the reason that we ultimately came up where we did. And of course, the American people completely embraced it.
We have a show of hands if you agree with that outcome.
Aaron, why don't we talk about like the way our findings got treated?
Well, I thought we were going to ask one more question, which was we did not get collusion.
I can touch that in maybe 45 seconds. I'll ask myself the question. The Bob's appointment order uses the word collusion, looking at collusion, potential collusion between the Russian election interference and members of the Trump campaign. And the question is, well, what does that mean? How did you think about that? How did you apply it? And the 45-second answer is collusion is not an actual concept in the criminal law. And so very early on, Bob took the decision that we would apply that as conspiracy. There's an established standard for conspiracy and a legal agreement. And so that was the criminal legal framework that we used when evaluating the potential interaction or the actual interactions between members of the Trump campaign and various Russian proxies. There were some instances that were not as easy to apply that to, and the one that we've been asked about a number of times that I thought was worth mentioning here is from July 2016. At that point, Donald Trump was still a candidate, and he gave a speech. And in the course of his speech, he said words to the effect of, "Hey, Russia, if you're listening, I think you'll be mightily rewarded if you can find these missing emails from Hillary Clinton." At the time, that was right around the time the FBI was concluding its investigation of the so-called private email server that Hillary Clinton had. And so this was, and I think some number of emails hadn't been recovered. And so Trump at the podium says, "Hey, Russia, if you're listening, you'll be rewarded if you find those." 5 hours later, first time ever, Russian military intelligence tried to break into Clinton's personal office email. And so what do you do with that? Is that a conspiracy? What do you call that? And so we actually took this on, and we brought that up to the introduction of Volume 1, because it's on everybody's mind. It's a little bit of an unusual one. And what we ultimately concluded there was, well, that we don't see an actual agreement. We don't think that's a conspiracy, but what we thought it might be is call and response. And so that was one of the more complicated scenarios, or ultimately not very complicated, but one that I think was not particularly well understood necessarily by the public. Do you want me to keep going on that, or do you want to pivot to?
I think just in the interest of time, we should pivot to how our report was handled.
So I think Brad touched on this in the beginning. So we concluded our work in March 2019, and on Friday, March 22nd, we wrapped up the report. We delivered it to Attorney General Bill Barr. And as I think Andrew already alluded to this, we understood from the AG Barr's confirmation hearing when he was becoming Attorney General that he was committed to transparency. And when he said that, we understood that to apply to our work, to Bob's work, to the report. And there were some other interactions with the Attorney General in the run-up to our delivery that caused us to think, look, if there's going to be any sort of public release about the results of our work, it'll be our words, our report. What ultimately happened, we delivered it on that Friday, and then 2 days later, on the Sunday, March 24th, we got word that the AG might have written a letter, his own summary and analysis of where we had come out. And so at that point, we got word of this potential letter. Our decision at that point was to push to not use the letter and instead to use our executive summaries and our introductions. That is not what happened, as history has shown. The letter that came out that day on March 24th from AG Barr was ultimately the initial recitation of what we had landed on. So our view was that was actually an action of withholding our report. We thought the AG's letter had mischaracterized fundamental pieces, important pieces of our report, and we think that came at a real cost because the facts were not our analysis and the work that we had done was not actually public, and there was a cost in the way that the public understood or didn't understand Russian election interference, and there was a cost in what the public did and didn't understand about the president's conduct. I'm going to lateral another hard one to Andrew to explain what were the fundamental mischaracterizations in the AG's letter.
And so, number one, he did say that we found no conspiracy, no collusion, but he did not say that we found that the Russian government not only had interfered in the election, but it interfered with the purpose of electing Donald Trump. He left off that last piece. He also left off that we said in the report that the Trump campaign was, in certain respects, willing and eager to accept that help, and it actually planned some of its strategy around receiving emails that had been stolen by the Russian government. With respect to obstruction, the Bill Barr letter, we call it in the book, we call it the Barr report, which is in contrast to the Mueller report. The Barr report also doesn't go into detail at all about any of the instances of obstruction, and doesn't recognize that for 4 of the instances that we talked about in detail and analyzed in the report, we actually had found that there was substantial evidence that each of the elements of obstruction were met. And instead, in the letter, Barr writes that we weren't able to reach a judgment about obstruction and had left the decision to him. And then he, as Attorney General and as authority of Attorney General, he made the decision that there was no obstruction of justice. And that allowed, and the letter comes out on Sunday afternoon, March 24th. And I think within an hour or two, we put this in the book, the White House put out a tweet saying, Mueller report concludes no obstruction, no collusion, the president's exonerated. And that was not what we had found.
I just want to add on. I know we're moving on to other topics, but the following morning, so Monday, March 25th, letter comes out that evening on the Sunday. The following morning, I immediately got in touch with the department and said, the letter's not right. And I ticked through some of the legal errors in the letter, and we asked, like, we want you to release our executive summaries, and we quickly went through them that morning, redacted anything that had anything that touched on grand jury information, anything that touched on ongoing matters, and we sent them over to the AG that day, the day after the March 24th letter, and Bob wrote a letter and said, we'd like you to release these. It's not what ultimately happened, but that was what happened the morning after the AG's letter was sent.
So I think in the interest of time, there are some audience questions, and we can kind of incorporate some of what we were going to ask about with some audience questions, and finish our last less than 15 minutes together. The first question we have, did the connections between Russia and persons associated with the Trump campaign continue post-election? Aaron, you want to take that?
Yes. We actually don't talk about this in the book, but the Mueller report does. There are three elements to the Russian activity. One is the Active Measures campaign, which was run by an entity in St. Petersburg, Russia, called IRA, Internet Research Agency. Social media campaign, Russians masquerading as Americans, trying to persuade people to vote a particular way. Russian military intelligence breaking into the DNC and the DCCC, stealing democratic emails and dumping them. And the third aspect was there were several elements of outreach by Russians and Russian cutouts. A lot of that happened in the course of the campaign, and some of it continued after the election as well. There's a couple of instances where there was additional outreach by the head of a bank, by the head of the Russian Sovereign Wealth Fund. There were some meetings in January 2017. Very famously, Sergei Kislyak, who's the Russian ambassador, was in touch with Mike Flynn, who was the incoming national security advisor. That was in December 2016. So there were other contacts afterwards. The Mueller report goes into this in great detail with lots of footnotes, but the book is an easier read, so I'd recommend the book.
This one I'll direct to Jim. Will Bill Barr ever be held accountable for his role in covering up for Trump, Rudy, etc.?
No.
This one I'll take. How does your view of the probe differ from Andrew Weissman's as offered in his account? So Andrew Weissman also wrote a book a few years ago about the Mueller investigation. And like the answer, like our book is a very different book. Andrew Weissman was the team lead for the Paul Manafort part of the investigation, and he moved that investigation very quickly and extraordinarily well. But his perspective on the decision-making of the office was limited in part because we were somewhat siloed in the information that we had. And the reality is that these guys around me, Aaron and Jim, along with Bob, were the only people who knew the entire swath of what we were doing, what our strategy was, what our investigation was. I was pulled in on obstruction matters and dealing with the president's lawyers. So our book sort of talks about all of that more broadly, and I think gives a perspective about the decision-making of the office that is new and that is different, and I think sort of talks about the principles that we were operating under in a way that is not covered by Andrew's book. Mr. Zebley, how does your experience and passion for architecture impact your writing?
I have a feeling that came from my sister-in-law. I don't know that it did, but we do describe the brutalist architecture of the FBI headquarters building, which is notoriously known as the ugliest building in Washington. So that was an important element of the book. I think we comment on the use of limestone to build DOJ headquarters. So that's about the extent of it. Thank you, Rachel.
One of the questions is, it goes back to where Aaron started, but I want to direct this to Jim. Why is this book relevant now with respect in particular to Russian interference?
Well, it's relevant for a number of reasons. One, we're now private citizens, but you don't have to have a high security clearance to know that Russia is continuing to involve itself in our elections. And, success breeds success. They are doing again what, as Bob said, they're interfering in this election, as are others, people like Iran. It's hard to sit and say, well, Russia's interfering. Everyone says, what can I do? Well, it's not easy to figure out what you can do other than to do two things. One, understand that they're doing it. And two, when something that you're reading on your preferred social media seems a little off, check and see whether the other people are talking about it, or is it something that's coming only to you? Because one of the things that the Russians did spectacularly was to figure out how to make this group believe that, make this group believe that, and then have those two groups be extremely mad at each other.
The next question, I think I'll take in the first instance and then punt over to Aaron. But what is it about the investigation that you would change? And look, the book talks about some mistakes that we acknowledge that we made throughout the life of the investigation. But I think more broadly, the thing that I would like to change is the impression that some people had of what we were doing and of Bob Mueller in particular. I think in the wake of our investigation, in large part due to the way that the findings came out, and it took a month for the findings to come out, there was criticism that Mueller was the wrong person for the job, that he was too much of an institutionalist, where you have people around you who are breaking all the rules, who are breaking the norms, who are floating pardons for people who are under investigation. Don't you need somebody who's willing to fight fire with fire? Are you bringing a knife to a gunfight? That kind of criticism. From my perspective, and I know that these guys agree, that when it comes to a DOJ investigation of the president, that I think that criticism has it exactly the opposite. That you need, in a situation like that, where the people around you are breaking the rules, you need to show in all that you do that you're doing it the right way. And that was Mueller's mission from the beginning. It was what he told us sort of on a day-to-day basis. And if you actually think through the opposite, should we have taken steps that were more aggressive just to be aggressive, just to sort of take on the president? If you think that through, all that's going to end up doing is undermining the rule of law, undermining the things that we were actually trying to do. And look, it's frustrating because if you're operating the way we were, under a set of rules and norms and trying to do everything the right way, and people around you are not. But I think over the long term, and part of the reason why we wrote this book is to show that down the line, this kind of an investigation run in the way that Bob ran our investigation is the right way to do it, and it ultimately will help the rule of law, even if you lose the ability to take some cheap shots along the way. So Aaron, what would you have changed?
I just want to add a little bit to what Andrew just said. I mean, one of the ways we thought about this is that you're sort of triggering a race to the bottom if you do fire with fire. And maybe the ultimate example of that, I won't quote anybody, but the idea of using the Department of Justice to go after your political enemies is sort of an iteration of this, which I think is a recipe for disaster if we end up in a place where that's how the Department of Justice is deployed. So the one thing I might change, and this is actually, it might sound like an obvious change, and I think Brad alluded to this, but it's actually a slightly complicated issue. And the thing I would change, just to put it on the table, is I would have changed the way in which we delivered the report to the Attorney General so it didn't play out the way it did. What's complicated about that is it's not typical, and I don't think we would want a system in which prosecutors are writing reports about uncharged conduct and then they're released. It's just not how the Department of Justice does work or should work. So it's complicated. But under these circumstances, where and the regulation reads to appoint a special counsel. You appoint a special counsel when there are extraordinary circumstances and conflict of interest, for example. So when the Department of Justice is investigating the president, that is a probably extraordinary circumstances. You do that because those are circumstances where it's important for the public to see what happened in the investigation in order for them to have public confidence in the outcome. So under those circumstances, there is some space, I think, for a report to be released. I think you do need the attorney intermediating in there. I think there's a role for the attorney general. But I don't think it's okay for the politically appointed attorney general to withhold the report and mischaracterize it. That was what our fundamental issue was. Had he released our report and then said these guys are a bunch of crazies, I disagree, I don't think I would have loved that either, but that would have been better. So that's what I would have changed. I would have changed the manner in which we delivered the report to preclude the sequence of events that we went through.
So in our last couple of minutes, we can close with Jim and give us some reflections on comparing this investigation to Watergate.
Well, there were some similarities in the sense that there was a lot of scrutiny, but there were a lot of things that were different. For example, in Watergate, there were essentially two newspapers who covered us, the Washington Post and the Washington Times, or the Washington Star, the evening paper. The New York Times covered us to some extent, but Woodward and Bernstein had such a running start on it that they had a substantial amount of coverage. There were also only 2 or 3 networks at the time who did it, so people were getting essentially the same story every night from those networks. Now you have the ability to select a network which will reinforce your perception. So if you think A, you can go to this channel. If you think non-A, you can go to that channel, which produces a much more divided group of people. But the thing I would close with is, Saturday Night Live started again last night. It was only 1 year after Watergate that they started. But the event that sort of indicated how much our investigation had gotten into the American psyche happened when Aaron and Bob and I were traveling around to our different offices. And we were giving a presentation on what we had done and telling people how we had approached issues. So we left the Denver office, headed to Palo Alto. I'm sitting in row 3. Hopefully no one from firm management is here and knows that I flew first class.
I was in the back.
And I'm sitting in row 3. Bob and Aaron are sitting in row 5. This woman walks down the aisle, turns to her husband earnestly, looks at Bob and says, "My God, Robert De Niro's on this plane." That's the difference.
Jim is the comic foil in the book too. You'll see.
So for those who missed that, Robert De Niro played Bob on SNL. So look, that's our presentation. Thank you so much for coming.
Thanks, guys.